you very much, Mr. President. Good morning, my lords. I appear on behalf of the appellant in this matter, Worcestershire County Council, along with Mr. Lee Parkhill to my immediate right and Mr. Oliver Jackson to my far right. I'm instructed by Ms. Anna Ost of Worcestershire County Council Legal Services. My learned friends are Mr. Tim Bewley, KC, and next to him, Ms. Natasha Jackson, who appear on behalf of the Respondent, the Secretary of State for Health and Social Care, instructed by Ms. Fareshta Shams of the Government Legal Department. Before I launch into my submissions, there's one housekeeping point. A short supplementary authorities bundle was filed with the court yesterday that includes 2 statutory provisions from the Mental Health Act. This should be with you in soft copy, but we have hard copies if that would assist.
No, we have that electronically.
Grateful, my lord. Just first, there's section 13 of the Mental Health Act, which concerns the process by which persons are detained pursuant to section 3. And secondly, there's a further version of section 117 that was in force at the time of the second section 3 detention commenced, i.e. June 2015, which is the critical date as far as ground 2, which I'll come to. The version in our bundle was in force at the time JG left hospital after the second detention, namely the 9th of August 2017, which is the critical date on ground 1. There's no material difference between the two for the purpose of this appeal, but I just thought for the sake of completeness, you should have it. My lords, the issues before the court today are of fundamental importance to all local authorities, many of whom are likely to face restitutionary claims for large sums of money stretching back decades on the basis of the Court of Appeal's decision. Fortunately for me, my lord, I don't think we're going to need to look at restitutionary matters today. Can I begin with a brief roadmap of my submissions? In the next 1 hour and 25 minutes, I intend to address our 2 grounds of appeal, which are in the alternative. I will make submissions on the respondent's cross-appeal on the meaning of the phrase ordinary resident in my reply this afternoon, for which I have an hour. This morning, I intend to make one short factual point before turning to 2 grounds of appeal, which both focus on the text of section 117. Finally, I will end with some brief submissions addressing points made by both the Court of Appeal and the Secretary of State on policy and practical issues. It will be brief, but I do need to respond on those. But the focus is going to be on the text of section 117. I also want to make it very clear at the outset that grounds 1 and 2 are mutually exclusive alternatives. They present you with 2 alternative ways of construing section 117. Ground 1 is that section 117 duty on the first local authority comes to an end when the person leaves hospital after the second period of detention. Ground 2 is that section 117 duty on the first authority comes to an end at the moment the person is detained again under the relevant statutory provisions listed in section 117(1). We accept that to succeed in this appeal, we need to succeed on either grounds 1 or 2 and successfully resist the Secretary of State's cross-appeal. So that's my introductory section. As I say, one quick factual point. We're, of course, focusing on the law, but I do want to make one point. The courts are frequently called upon to determine disputes between local authorities as to which local authority has responsibility for a particular individual. That's not just under the Mental Health Act. Such disputes regularly arise under the Children Act, National Assistance Act 1948, and the Care Act 2014. In some of those cases, particularly those involving the Children's Act, there are issues relating to local authorities. The phrase sometimes used is dumping individuals outside their area in a deliberate attempt to evade legal responsibility for such an individual. Courts have rightly been critical of that conduct, but this case is very far removed from such a situation. It is common ground that the decision to place JG in Swindon was not done in an attempt to evade responsibility. Can I ask you to turn up the Secretary of State's review determination, which is the decision under challenge here, which is tab 17, and I'd like you to turn to page 301 of the bundle. I understand that some of you may be using hard copies, is that correct?
Well, it's best if you give us the electronic page numbers. We have everything electronically. We only have in hard copy essentially the parties' submissions and the judgments below.
Okay. I thought there were tech issues which might have changed the normal approach, but that's very helpful. So page 301 in the electronic bundle. At the bottom of page 301, this is the Secretary of State's review determination. Secretary of State says, I recognise that in the present case, the decision to house JG in Swindon was not the result of a deliberate decision to evade responsibility under section 117. Indeed, in this particular case, it was the result of JG's sister living in Swindon, and it's argued by Worcester that following the move, JG had no remaining ties with Worcestershire. So it's common ground. There was nothing inappropriate here. And we say there's far less scope under this particular statutory regime for such dumping. If the individual who leaves hospital has capacity, it's a matter for them where they choose to live. If, like this case, they lack capacity, it's a decision for the local authority, but it has to be in the best interest of the individual, and that decision is taken with input from the family members. And in this case, the reason for the location was where JG's daughter lives. So we say there's very little scope for dumping or deliberate passing of responsibility here. That's all I want to say about the facts. Going to get stuck into the law now, my lords. Turning to ground one. Ground one is that the section 117 duty on the initial local authority, in this case Worcestershire, ends at the moment when the section 117 duty is imposed on the second local authority, in this case Swindon, namely when the person leaves the second hospital after the second period of detention under section 3, in this case the 9th of August. My lords, in my submissions I will refer to the duty being on the local authority. However, as I'm sure you're all aware, it's a joint duty imposed on both the local authority and at the relevant time the CCG, the Clinical Commissioning Group. In this case, neither of the CCGs are part of this dispute, I understand, because Swindon CCG has accepted responsibility for JG throughout. My lord, I'm going to address you on ground one under two broad headings. Firstly, I'm going to address the wording of section 117. This is to show you that section 117, on its normal operation, gives rise to two competing duties in this case. Secretary of State's written case makes much of the fact that our arguments on ground one depend on this premise, and they say there are no two competing duties and therefore ground one fails. We accept it's a necessary part of our argument on this ground, that the normal operation of section 117 gives rise to two competing duties. Secondly, I'm going to address you on how these otherwise competing duties can be resolved. You should note that the competing duties point only arises on ground one, not ground two. So, turning to my first heading, the words of section 117 would usually give rise to two competing duties in this type of case. I'm going to take this in two stages. Firstly, I'm going to look at how section 117 and how we say it operates. And secondly, I'm going to respond to the Secretary of State's points and the Court of Appeal's reasoning on this point, albeit they're broadly the same. Could I ask you to turn to page 357 of the bundle, where you will find section 117. Section 117 and the first part of section 117 subsection 1 and the first part of subsection 117.2 set out how a duty arises. Section 117.1 is the gateway provision, and it says this section applies to persons who are detained under section 3 above. It makes reference to other provisions which are not relevant to today. They're in the bundle, but I don't think I need to take you to them unless you would like me to. So this section applies to persons who are detained under section 3 and then cease to be detained, and brackets whether or not immediately after ceasing leave hospital. The second reference to detained in section 117.1 is clearly a reference to detention under section 3 or one of the other statutory provisions referred to in subsection 1. we say two conditions need to be satisfied here. Firstly, that the person is detained pursuant to Section 3, and secondly, that such a detention ceases and the person leaves hospital. My Lords, before we continue with our consideration of Section 117, I think it would be useful to briefly at this point turn up Section 3 of the Mental Health Act, which is page 345 of the bundle. Now, I know at least one member of this court has some familiarity with this statutory scheme. Section 3 is admission for treatment. Now, the initial admission for treatment is for a period of 6 months, albeit it can be ended shortly. That can be renewed multiple times. It can essentially go on ad infinitum. Now, sorry,
where do we find the 6 months?
You find that in Section 20, which isn't in the bundle, my Lord. I apologise for that. If the court...
So it's a minimum period?
Well, no, the initial detention pursuant to Section 3 is for 6 months. That doesn't mean they have to stay for six months because...
They can be discharged.
Exactly, my Lord. But that's the initial period. The first renewal is another 6 months, and thereafter it's yearly renewals. Now, Section 1 says a person may be admitted to a hospital and detained there for a period allowed by the following provisions of this Act in pursuant to an application made in accordance with this section. That's where the supplementary bundle comes in, my Lord, because that details the application process. So if I could ask you to turn to the supplementary bundle, page 2, which is Section 13, duty of approved mental health professionals to make an application for admission or guardianship. Section 1, if a local social services authority have reason to think that an application for admission to hospital or a guardianship application may need to be made in respect to a patient within their area, so it's not ordinary residents, they shall make arrangements for an approved mental health professional to consider the patient's care on their behalf. So the duty there falls on the local social services authority where the individual is physically located. In this case, that's Swindon. And what actually happened is Swindon instructed one of their employees, an approved mental health practitioner, to assess. So Swindon had involvement at this stage in relation to the second detention. Worcestershire had no involvement at this stage. That's how someone gets detained under Section 3, or that's the main route. There is a further route by which nearest relative makes an application, but that's extremely rare and not relevant to this particular case, my Lord. It might be worth at this point just taking you to page 344 in the bundle, which is Section 2 of the Mental Health Act. Again, you may well be familiar with these provisions. This is admission for assessment as opposed to admission for treatment. This is for a maximum period of 28 days. Similar involvement of AMHP. So Section 2 and Section 3 are different. Assessment, treatment. Section 2 can't be renewed. Subsection 4 makes it clear it's for a period not exceeding 28 days. It does say subject to Section 29.4. 29.4 isn't in the bundle, but that's where there's an application to court to appoint an acting nearest relative. Again, extremely rare and not, we say, of any relevance. If we could now turn back to Section 117. 357, my Lord. So we've looked at the text of 117.1, which we described as the gateway provision. Turning now to Section 117, subsection 2, this is the trigger provision. it shall be the duty of the local social services authority to provide aftercare services for any person to whom this section applies. My Lord, we say it follows that Section 117 is newly engaged by each separate instance of detention under the relevant provisions. You will note this is in our written case at para 59, page 132. I have 4 short points on this. Firstly, Section 117, subsection 1, is phrased in the present tense. This section applies to persons who are detained under Section 3. It is engaged when a person is detained pursuant to Section 3 and then ceases to be detained and leaves hospital. Second, another way of looking at Section 1171 is that a person is brought within the scope of this section each time they are detained under the relevant provisions of the 1983 Act and then released. A person who is in hospital for a second or subsequent period of detention is still a person who is detained. Third, crucially, there is nothing in the statutory language to suggest that, once the criteria in Section 1171 have been met on a single occasion, pursuant to a single period of detention, they are fixed or locked in regardless of any future periods of detention. Fourthly and finally, Section 1172 then triggers a duty on the relevant authority to provide aftercare services to any person to whom this section applies. The word applies in Section 117, subsection 2, refers back to Section 1171. And as I've just submitted, Section 1171 applies to all persons who are detained, present tense, under Section 3 and then released from hospital. I use the phrase released from hospital here as shorthand for compulsory detention under Section 3 ending and the patient leaving hospital. So we say Sections 1171 and 2 operate by placing a duty on the local authority in respect of each period of detention under the relevant provisions of the 83 Act, which is triggered when the person leaves hospital. Then Section 1173A tells us which local authority is placed under the duty to provide aftercare services. 113A is over the page at page 358 of the electronic bundle. And 1173A says it's the local authority where JG was ordinarily resident immediately before the Section 3 detention. Well, it doesn't say Section 3, but that's clearly what it refers to. It is now common ground that the detention referred to in Section 1173A is the individual's most recent detention pursuant to Section 3. Pausing there on this point, could I ask the Court to turn to Mr. Justice Linden's judgment, firstly at page 243, my Lord. Which is where it begins. And could I ask you to turn to page 249, at paragraph 29 on 249, the Court sets out the Secretary of State's decision that is subject to challenge. I'm sure you've already seen this. There are 3 propositions set out. The first proposition is the subject of the cross appeal. The third proposition is the subject of my appeal. And the second proposition is not the subject of appeal at all and wasn't to the Court of Appeal. So you'll see at the top of page 250, Mr. Justice Linden setting out the second proposition, and that concerns the phrase immediately before detained in Section 1173. The Secretary of State concluded that that was a reference to the first detention, not the second detention. That was challenged, well, all 3 propositions were challenged, and if I could ask you to turn to page 275 of this bundle, where Mr. Justice Linden addresses proposition 2, and the critical paragraph is paragraph 136 over on the page 276. Where the court says, I reject proposition 2. It seems to me that section 117 contemplates that on each occasion that a person is to cease to be detained under section 3 or any of the orders or directions referred to in section 1171 of the 1983 Act and is to leave hospital, the question as to appropriate aftercare services will arise and will be addressed whichever body owes the section 117 duty at that time. Consistently with this, the responsibility for the services to be provided after the period of detention will fall on the area in which they were ordinarily resident, etc., when the decision to detain them was made. Immediately before that period of detention, I do not consider the words of the provision ambiguous or unclear. So that wasn't the subject of appeal to the Court of Appeal, and it's obviously not before the court. Now, we say that the Secretary of State's argument before you today is to simply ignore the second detention when deciding which local authority the duty rests. Secretary of State says the existing duty arising out of the first period of detention continues, so no duty arises from the second period of detention. We say that's inconsistent with Mr. Justice Linden's conclusion of paragraph 136 on proposition 2, which of course has not been appealed. So Mr. Justice Linden decided the point, considered it clear, wasn't appealed. I'll of course deal with what my learned friend has to say, but we would emphasise this point. That is all I wanted to say about how Section 117 operates under Ground 1. We say it's clear. Section 117 is newly engaged by each separate instance of detention under the relevant provisions set out in Section 117. So where you have two separate periods of detention and release from hospital, as in this case, you have two competing duties. Now, the Secretary of State arguments in response to this are set out in his written case. I think paragraph 57. Could I ask you to turn to page 172 of the bundle, my lords? As we understand the Secretary of State's analysis, he says Section 117 sets out preconditions for the duty to apply to a local authority. He says that once those preconditions are met, they're fixed or locked until the duty is brought to an end by the second part of Section 117.2, regardless of a further period of detention. That's most clearly set out in paragraph 57 of his written case, which I think if I could ask you to read that to yourselves. So I'm then going to explain why it's wrong.
Basically, the argument is that the section already applies, it can't apply again.
Yes, well, that's the argument in a nutshell, and that's, we say, inconsistent with the statutory language, which is the point I'm going to now take your lordships to. Section 117.1 does not say this section applies to persons who have been detained. So it doesn't say this section applies to persons who have been detained, or this section applies to persons the first time they are detained. The Secretary of State's case on this point involves rewriting Section 117.1. What section 1171 says is the section applies to persons who are detained. It's phrased in the present tense. Section doesn't fix on the first period of detention only. To repeat, a person who is in hospital for second or subsequent period of detention is still a person who is detained. Now, my lords, to the extent that paragraph 56 of the Secretary of State's written case is saying something different to paragraph 57, for instance, that his preferred construction can somehow be manufactured out of the word applies, it is also wrong for the same reason. There's no magic in the word applies, such that a statutory provision can only apply once and never again. It's necessary to look at the context in which the word is used. Again, section 1171 applies to persons who are detained. A person who is in hospital for a period of detention, regardless of whether there have been previous periods of detention, is a person who is detained.
Well, I don't think that's in dispute, is it?
Well, I think...
supposing a patient has been detained, they're released, they then have aftercare, that aftercare is brought to an end, and then they're detained a second time. That would be a case where someone has been detained for the first twice now.
Yes.
It's not suggested by the other side that section 1171 and 2 wouldn't then apply.
Not in that situation, no. But we're obviously in slightly different...
So, reading in the words you were suggesting into 1171 would really destroy the purpose of the section so far as the sort of person I've identified as concerned.
Well, absolutely, my lord, but they have to read them in to deal with this particular situation.
Do they?
Well, my lord, we say yes, because of the use of...
But if you read those words in... How do you deal with the situation I've just put to you?
Well, you don't, my lord. That's the problem with reading those words in, but those words need to be read in to deal with the situation in the present case. And they can't be read in because they would cause problems with that type of case. So, my lord, I'm agreeing with you.
Sorry, why do they have to be read in?
Yeah, I haven't quite followed your main point here.
Well, they have to be read in because reading the words as they are written, they apply to each particular detention pursuant to section 3.
Well, yes, and that's what gives rise to the competing duties. You say there's a competing duty arising because subsection 1 does apply to each period of detention. That's common ground, and therefore you say that there's a duty under 2. But the Secretary of State says no because it hasn't terminated under subsection 2.
My lord, I don't think it is common ground. I think my understanding of the Secretary of State's case is there are no competing duties in this case.
I appreciate that.
That's what the Court of Appeal also decided.
It's common ground that subsection 1 applies to each period of detention. What is not common ground is whether on the second detention, if the aftercare following the first detention has not been terminated, a duty arises. That's what's not common ground. But as I understand your argument, you say, well, the subsection 2 gives rise to a duty on each detention.
Yes, my lord.
And the Secretary of State says it only gives rise to that duty if it has, on a second or subsequent detention, if the aftercare has been terminated.
Yes, my lord.
The point you're addressing at the moment is the point that it can't apply concurrently, because if it already applies, it can't apply again. That's the argument you're addressing.
Yes, my lord. Yes, my lord. And we say that is inconsistent with...
What's wrong with that argument? What's wrong with the argument that if it already applies, then there's no re-engagement if you're when you're detained in hospital?
Well, what's wrong with that argument is it's not consistent with the language of section 117, subsection 1. Because if you look at the language of subsection 1171, it says this section applies to persons who are detained under section 3. Yes. So second detention, they are detained and then cease to be detained and leave hospital. The use of the present tense, we say, clearly means that a second duty is triggered by the second detention. And that's why we say in the particular circumstances here, what that section 117 does not say is this section applies to persons who have been detained in the past, or this section applies to persons the first time they are detained. That's not what the language is. The language is in the present tense, and we say it's clear from that the gateway provision is met on each detention. That's our basic point. I
don't see why the language is inconsistent with an argument that says once the section applies, unless it ceases to apply, that's it, and whatever happens after that doesn't matter unless it disengages the duty.
Well, if that was the situation, and I can see there's some support for that argument from the second part of section 1172, but then you're essentially ignoring, in this circumstance, the language of 1171, the first part of section 1172, and 1173, which tells you which local authority the duty falls on. Immediately before the most recent detention, it's that local authority, see proposition 2. And immediately before the second detention, that was Swindon, not Worcestershire.
Yes, that's what you say. That is one duty, and you say that's one competing duty. They say the other competing duty is a continuing duty on, as it were, the first local authority, shall I call it?
Yes, we say at this point, because our original duty hasn't been brought to an end by a joint decision pursuant to section 1172, there are two duties in place.
That's right.
As I understand it, the Secretary of State's cases, you never get to two duties. But we say that's inconsistent with the language of subsection 1 and the first part of subsection 2 and section 1173. So the first part of our argument is, are there competing duties? Our case is there is. As I understand the Secretary of State's case, there is not. If you're against me on that, we lose on ground 1. But that's not sufficient for me to win on ground 1. I accept that, because you've got these two competing duties, and you then have to resolve which one matters. So our argument requires two steps. My Lords, I could take you to the Court of Appeals analysis on this point, which is paragraphs 50 and 54, but it's broadly the same. So paragraphs 50 and 54, page 232 of the bundle, but it's broadly the same as my Secretary of State's argument. They conclude there was only ever one duty as long as the original duty subsisted. The question of competing duties does not arise. So that's, they say there are no competing duties. That's what I understand the Secretary of State is saying. We say no, that's inconsistent with the clear language of subsection 1 and the first part of subsection 2. It fails to recognise the normal operation of section 117, which we say means two separate duties are triggered as a result of the two separate periods of detention. That was the critical error in the court's analysis. Their analysis ignores the fact that the person does fall within the section 117 gateway with the second detention and subsequent release, ignores the fact that a further duty to be triggered pursuant to the first part of section 1172, and critically ignores what section 1173 says, particularly in light of Mr. Justice Linden's unappealed conclusions. We say the Court of Appeal's interpretation therefore does drastic damage to the functioning of the statutory mechanism, disregards first subsection, first part of the subsection, and all of the third subsection. Given the time, I'm not going to take you to Mr. Justice Linden's judgment on this particular point, but for your note, our case is consistent with that judgment. See paragraph 149 at page 279 of the bundle. So, to conclude the first half of my argument on ground 1, salient issue is the point I made earlier. On the usual functioning of the language of section 117, two duties arise where there are two periods of detention in two hospitals in two different local authority areas. We say, and this is agreed, this cannot be correct. The existence of two competing duties is unsustainable, and both the High Court and the Court of Appeal agreed with that analysis, and it's common ground. The question then is, if you accept our argument on the competing duties, is how one resolves the problem of those competing duties, which brings me to the second head under ground one, resolution of competing duties. I'm going to take this in three stages. First, I will set out the interpretation of Section 117, and our interpretation, Section 117 under this ground. Secondly, I will show you why the Secretary of State's objections are misplaced. And thirdly, possibly if I have time, we'll look at Mr. Justice Linden's judgment on this. So, first part of my argument on this, our interpretation of Section 117 on ground one. We say the duty on the first local authority ends at the moment when the duty is imposed on the second local authority, i.e. when the person leaves hospital after a further period of detention under the provisions listed in Section 117. This interpretation gives best effect to the overall functioning of Section 117 and the purpose of that provision. Again, can we look back at page 357 where you find Section 117? So I have 4 points on this. First, our interpretation fixes the duty to provide aftercare on the local authority for the area where the person was ordinarily resident immediately before they were detained. Again, this accords with Mr. Justice Linden's conclusion on Proposition 2. This is the usual functioning of Section 117 in cases where there is no prior period of detention. In other words, this interpretation is consistent with the normal operation of Section 117 in nearly all cases, apart from the particular unusual facts we have here. Secondly, it gives effect to all of the different parts of the Section 117 mechanism. The person falls within the gateway provision of Section 117.1. The duty is triggered when a person leaves hospital after the second detention, as required by the first part of Section 117.2. It is placed on the local authority for the area where they are ordinarily resident immediately before that period of detention, per Section 117.3, and it can still be brought to an end by that local authority and the local health bodies when they are satisfied that the person doesn't need any more aftercare. So it accords, it doesn't render any of it otiose or redundant. Third, it's the interpretation that gives best effect to the duty in Section 117 on local authorities in question to cooperate with relevant voluntary authorities. Local authority best placed to engage in such cooperation is clearly the authority for the local area, not an authority that may be at the other end of the country. Fourthly, it ensures that persons remain eligible for Section 117 aftercare for as long as it is required.
Just repeat your fourth point, please.
Yes. It ensures that the person remains eligible for Section 117 aftercare for so long as it is required.
Well, both arguments have that effect, don't they?
Yes, my lord, but yes, I would accept that point.
I mean, your case is that the second duty displaces the first.
Yes, my lord.
And the opposite argument is that the first duty is already there, so there's nothing you can't be displaced, or it isn't displaced.
Yes, that is there we are, my lord, yes. Now, we say our interpretation with Section 117 is consistent with the purpose of the second part of Section 117.2. We have 3 points on that. First, the purpose of the second part of Section 117.2 is to ensure that the person concerned receives care for as long...
You're going quite fast as far as I'm concerned.
I do apologise.
So you say that this is on the second part of Section 117.2. You've got
Yes.
3 points, and the first is what?
The purpose of the second part of Section 117.2 is to ensure the person concerned receives care for so long as that care is necessary and they are eligible. that purpose is entirely maintained by our interpretation, but I accept the point made by Lord Leggett that that would also apply to the other interpretation. Secondly, we say the purpose is actually strengthened. The authority responsible providing them with care is the one in the area for where they are likely to be actually living. That authority is also likely to be closer to the detaining hospital, so it will be easier for that local authority officers to visit, liaise with healthcare, etc., and plan for discharge. Thirdly, there is no easy way out for the initial authority that was fixed with the duty arising from the previous period of detention. They remain fixed with that duty for so long as the person needs it, unless the person is detained in hospital and released again. That is a matter outside their control. Further, we say that a joint decision under section 1172 is not the only way by which a duty can come to an end. For example, the death of an individual would bring the duty to an end without the need for a joint decision. We say the second detention pursuant to section 3 is similar to effect of death. It brings the duty on Worcester to an end.
Can I just ask you as regards the purpose? You've not mentioned anything about continuity of care, which I think was a big point made in at least the Court of Appeal and elsewhere, including, I think, in the intervention by mine. But I don't know how you read that purpose. Whether you think it's got any relevance at all.
Well, I was planning to address that, my Lord, in my policy and practical points section, but just to sort of give you a sneak preview, there is no evidence before this court or any of the other courts that our interpretation is a problem. That was the status quo that existed for at least a decade. The Secretary of State put in no evidence to support that. Mine's evidence doesn't support a problem with the status quo, our interpretation, and their submissions indeed tend to support us. And there's a blog from the leading commentator, Professor Clements, who also addresses this point and also supports us. So the concerns are wholly speculative and wholly misplaced, is the summary, my Lord, but I'll develop that later when I've got time.
I mean, the Secretary of State's guidance would presumably have been prepared having regard to practical implications.
Well, absolutely, and we have the most recent guidance that was amended in light of the Cornwall decision. That's the 2016 guidance as amended. 2011, 2013 guidance says the same thing. There's an express provision that deals with this particular type of case, and it says, in this particular type of case, it goes to Swindon. That's been operating for 10 years at the very minimum, since 2011 guidance. We as a local authority are obliged to act in accordance with that guidance. So one point may be put against us, well, why didn't you terminate pursuant to section 1172? The answer to that is we were told we didn't need to because the guidance says duty automatically transfers to Swindon on the second detention.
Just the reference to that guidance in the bundle.
Yes, my Lord. The current guidance is tab 52, page 9.
Sorry, just say, when you say the current guidance, what year is that?
I think it was issued in 2016, but it's been amended.
So you referred to the 2011 guidance a moment ago.
Yes, and this is all in our written case.
Okay.
If I take you...
Just to give me the reference.
Yes, certainly. The 2011 guidance is tab 50, page 957.
Right.
The 2013 guidance is tab 51, page 959. And the current guidance, which was issued in March 2016 and has been amended, you're looking at paragraphs, I think, 19.64, which is page 965, tab 52, my Lord.
You know, we have evidence of a guidance isn't giving guidance to this court as to the correct legal interpretation. But the only point that struck me was that it would be surprising if if the guidance had caused practical problems which hadn't been addressed.
Well, my Lord, I completely agree. It doesn't tell the court how to interpret it. I was referring to the guidance solely on the response of continuity, the practical policy, to meet the arguments being advanced against me. There is nothing in them, my Lord. And to the extent we do have evidence from mind, log from leading practitioner in this area, our interpretation provides better continuity. My Lord, I've got I was planning to finish ground one in the next 3 or 4 minutes.
You were talking about the duty under subsection 2 can come to an end other than by a decision of the local authority.
Yes,
you were beginning to develop that.
Yes, and I gave the example of death.
You did, yes.
Yes, which would bring
obviously
that to an end. And we say that the subsequent detention pursuant to Article Section 3 is a similar. I appreciate that.
Can I ask you this? What aftercare is provided once a patient is detained? So a person in the position of JG here, they were being provided with aftercare in the Swindon area, but by your financed at any rate by your client. So once she was detained in the Swindon area, what aftercare was then being provided, which was being financed by your client?
Well, once detained pursuant to Section 3, no aftercare was being provided.
No,
and I think it's common ground that once someone's detained pursuant to Section 3, there is no role for aftercare because Section 1176 sets out the purpose of aftercare, and it's to stop you deteriorating.
So are you saying then that detention, for example, under Section 3 is for these purposes analogous to death?
It's essentially, my Lord, yes.
That's the other way you put the case, which you haven't yet come to it.
Yes, my Lord.
You sort of jumped the gun here because logically, if your second argument is right, you never get to this point.
Yes,
because you're saying that if your first argument is right, then when somebody's detained, then that's the end of the of the duty.
Yes.
You don't have this problem to resolve.
Absolutely, my Lord. And there's a very helpful dicta in the Court of Appeal's CXF that we're going to look at in a minute.
Well, they might have been addressing a different sort of situation, but still.
Well, yes, my Lord. So,
it rather sounds at the moment as though your first ground really depends on your second ground.
No. Our first ground has 2 points. Firstly, one, the normal operation of Section 117 gives rise to competing duties. If that is right, we say there can only be one duty, common ground. We say it should be resolved that it's a second local authority, and that's what I've just addressed you on. The second ground is very much mutually exclusive. It's in the alternative. And that is that the Section 3 duty comes to an end when detention pursuant to Section 3, not any detention, it has to be detention pursuant to Section 3, and I want to come to that very shortly because we have a tight timetable. But no, our first argument is definitely not dependent on our second argument. They're mutually exclusive.
You don't need the first argument if you're right on the second.
No, and we
never get to a conflict of duties, which then needs to be resolved.
We don't, and we don't need our second argument if you're with us on the first argument. They're completely different alternatives. We say they're both ways that you can interpret Section 117 that accords with both the language and the purpose of the provision. My Lord, I think given where we are on time, it makes sense if I crack on to ground 2, because...
Just before you leave ground 1,
yes,
do you say that words have to be read in for your ground 1 or not?
Yes, we accept.
You accept that?
We accept that, my Lord, and actually that's something I've just skipped ahead. That was one of the Secretary of State's broad objections. We need to read in words. We've never shied away from that. That is in clear terms in our application for permission to appeal to this court. But we say it's true for the Secretary of State's interpretation as well. The Secretary of State the interpretation favoured by the Secretary of State would have the effect of reading words into the start of subsection 2 unless already subject to a duty under this section. So basically, the language of the statute doesn't really deal with what we've got here.
No.
Or it definitely doesn't deal with it clearly, which is why it's had to come this far to be resolved. But we say, we accept we need to read words in, but we say, so does the Secretary of State. Yeah.
Forgive me, I'm sure you've set them out somewhere, but just tell me, what are the words you read in? Where do you read them in?
We do set that out. We read them into section 2.
I think it's 89, isn't it?
It's 89.
Very good. Page 140. Paragraph 89. So as I say, we don't shy away from that, but we say that's true of the Secretary of State's interpretation. And the point we make is the express wording of the statute simply does not address the present situation. This situation was not considered by anyone when the provision was unusually added by an amendment in the House of Lords without government support during the passage of the 82 Mental Health Amendment Act. And we detail the background, paragraphs 25 to 32 of our written case. It's the court's role to interpret and apply it as best as it can, having regard to the functioning and purpose of the provision. My Lords, can I now turn to section ground 2? An alternative submission is the section 117 duty on the first local authority to provide aftercare services comes to an end when the person is detained in hospital for a second time under one of the provisions listed in section 1171, in this case section 3.
Can you just help me with, when it refers to the other provisions there, such as admitted to a hospital under section 37, are those all different forms of detention, are they?
Yes, a couple of them involve coming from prison. One is a decision of a higher court. They're all pretty rare. The vast majority of Section 117 cases are Section 3 cases.
Sure, but although it only uses the word detained in relation to Section 3, it's all the forms of admission are forms of detention.
Compulsory detention, yes. The word detained applies whatever the provision that gets us to section 117. So if it's not a section 3 case, if it's a 45A case, it's detained under 45A.
Yeah.
I think that must come out of subsection 1, doesn't it? And then cease to be detained.
Yes.
Well, it's implicit that they have been detained.
Yes.
Then.
Yes. And it's detained pursuant to one of the powers, just focusing on section 3 today. All the other provisions are in the bundle, but I don't think it's going to assist the court today to turn them up. So, as I said earlier, under ground 2, no issue of competing duties, as local authorities' A duty to provide aftercare ceases upon detention for treatment pursuant to section 3. Local authority B's duty arises when they cease to be detained and leave hospital. This is an alternative argument and falls to be considered if the court rejects our first argument. Going to develop it under 2 headings. First, our interpretation of section 117 under this ground. Section, a response to the Secretary of State and the courts below. My Lords, my simple submission under ground 2 is that at the moment that a person is redetained under the provisions in the 1983 Act expressly referred to in section 117, then section 117 no longer applies to them. They are no longer a person who has ceased to be detained pursuant to section 3 and has left hospital. And so they no longer meet the criteria set out in section 1171. On this ground of appeal, it's submitted that section 1171 sets out the criteria which must be satisfied on a continuing basis to the section 117 duty to subsist on a local authority. We turn back to the text of section 117, page 357. Section 117, subsection 1 provides that this section applies to persons who are detained under section 3 above and then cease to be detained and, brackets, whether or not immediately so ceasing, leave hospital. Having regard to the statutory purpose of this provision, my submission is that the words at the end of section 117, cease to be detained under one of the provisions and whether or not immediately so ceasing leave hospital, sets up one composite criterion that must continue to be satisfied on an ongoing basis for section 117 to apply to a person. If that
Do you need that argument, I mean, that linguistic argument, or can you just argue that if somebody is detained, that displaces any duty to provide care which is necessarily in a situation where they're not in detention, just in the same way as death would, for example?
Well, I think if you use the word detained as meaning detained under the provisions set out in section...
Yes, that's what I meant, yeah.
That's quite important because you can be detained under section 2 of the Mental Health Act, which doesn't give rise to aftercare responsibility.
I see. So that's their point, that we're putting it proves too much.
Well, yes, but that did not take into account our argument that we have a composite criterion, detained pursuant to ceases to be detained pursuant to section 3 and then leaves hospital.
But aftercare here is concerned with what is required after a detention and a release from detention. It's not concerned with what may be required during a voluntary stay or after a voluntary stay, or even after a section 2 detention, which, as you say, is only for a maximum of 28 days
yes.
and can't be repeated. So in those circumstances, one can readily see that the need for aftercare continues, notwithstanding the patient being in hospital.
Well, my Lord, yes, that's absolutely our point.
I see.
If you have a section 2 detention, that has no impact on Worcester's duty. And in fact, the second detention, section 3 detention in this case, was preceded by a section 2 detention, which is quite common. Often people are detained for 28 days to be assessed, and then they're subsequently detained pursuant to section 3 because within those 28 days it's clear that they're not going to be better and they need longer detention. So if there was a section 2 detention alone, our section 117 aftercare obligations would continue. Similarly, if there was a voluntary detention. And the courts below said our argument proved too much because they said if someone is detained pursuant to section 2 and then released, that would bring our duty to an end. And we say no, that's not a case because the issue is whether the composite criterion is satisfied, whether they cease to be detained pursuant to section 3 and whether or not immediately so ceasing leave hospital. Now, the Secretary of State's argument is the 3 criteria, but we say that there's essentially 2 criteria.
Well, the duty doesn't begin if you've ceased to be detained but are still in hospital.
Precisely, my Lord, yes.
Well, that's a point against you I'm making.
My Lord...
As to why they're not composite criteria, but they're a series of criteria.
You can definitely construe them as 3 criteria. We say the most... The construction that accords with the language and the purpose of this provision is to construe them as 2, and the second one is a composite criterion that requires to be continually met. I quite accept there are other potential constructions. I'm not saying we've got the only construction.
No, you're saying you've got the best one.
But yes, my Lord, that's very, very true. We say if this construction is right, it follows that section 117 is logically precluded from applying to a person who is currently detained under section 3 or any other relevant statutory provisions because they no longer satisfy the second composite criterion in section 117. I.e. that they've ceased to be detained pursuant to section 3 and have left hospital. We say...
So the proves too much argument is just a false argument because it's it's not dealing with the point that you have to have detention under Section 3 or as otherwise specified.
Yes, my lord.
1171. Other forms of detention or voluntary admission to hospital are just outside the ambit.
Yes.
Nothing to do with it.
Yes, that's absolutely correct, my lord. Can I ask the court to turn to page 786 of the bundle, which is the Court of Appeals judgment in R on the application of CXF against Central Bedfordshire Council. It's tab 45, begins at page 776. Issue in this case is whether a patient's trips on days out from hospital constituted aftercare services on the basis he had ceased to be detained and left hospital when he went on those trips. Court of Appeal rejected that argument, and paragraph 38, which is a judgment of Lord Legate, or Lord Justice Legate as he then was, addresses the purpose of Section 117 in language we don't think we can improve on. And paragraph 38 says, clear purpose of Section 117 is to arrange for the provision of services to a person who has been, but is not currently being, provided with treatment and care as a hospital patient. That purpose is implicit in the very expression aftercare, which is used not only in the heading but throughout the body of Section 117 in the phrase aftercare services. It's further articulated by the definition of aftercare services in Section 1176. As specified in Section 1176B, to constitute aftercare services, the services must have the purpose of reducing the risk of deterioration of the person's mental condition and accordingly reducing the risk of the person requiring admission to a hospital, again for treatment. So it's for treatment, it's to prevent a Section 3 detention. That purpose is only capable of being fulfilled if the person concerned is not currently admitted to a hospital at which he or she is receiving treatment for mental disorder. We say that is entirely correct, my lord. A person who is detained in hospital under Section 3 is being provided with treatment and care as a hospital patient in connection with that detention. Such a person therefore falls outside the scope of the duty to provide aftercare services as defined by Section 117. Accordingly, the duty comes to an end when they start being provided with treatment in hospital in connection with detention under one of the statutory provisions listed in Section 1171. Now, that's our case on it. I'm now going to deal with the Secretary of State's case and explain why that's misconceived. They advance three broad arguments on this. Firstly, paragraph 81 of their written case, they say it doesn't fit with the language of Section 117. They say that Section 117 contains three criteria that are independent of each other and are one-off matters. Once each one has been independently satisfied, they are spent. So he says it's wrong to view them as being capable of being satisfied on an ongoing or continuing basis. Well, our response is properly understood. There are two criteria. Firstly, detention under Section 3, and then ceasing to be detained under Section 3 and leaving hospital. We accept that the statute can be read as if the criteria in Section 1171 are one-off matters to be satisfied sequentially. But we say it can also be read on the basis that the final words of Section 1171 set up a single composite ongoing criterion that must continue to apply for the section to be engaged. The latter interpretation, we say, makes more sense given the purpose of aftercare being provided under Section 1176B is to reduce the risk of deterioration of the person's mental health condition and accordingly reducing the risk of the person requiring admission to a hospital again for treatment. The statutory purpose is rendered entirely pointless where a person is re-detained for treatment under Section 3. So that, we say, supports our interpretation on ground 2. Secretary of State's second objection is the submission is wrong because it must mean that the duty will be terminated by any subsequent stay in hospital, even a voluntary one. See paragraphs 83 to 85 of the Secretary of State's case. And this, which we've already touched on and was addressed by the courts below and raised by the courts below, we say this is wrong. Section 117(1) is entirely silent on voluntary admissions to hospital or short stays pursuant to Section 2. It is concerned with specific provisions of the 1983 Act, such as detention for treatment under Section 3. When Section 117 refers to the continuing criteria that a person must, quote, cease to be detained and whether or not immediately so ceasing leave hospital, in order for Section 117 to apply, it's plainly referring to persons who are no longer in hospital pursuant to Section 3 or the other provisions referred to as Section 117(1). There is no reason at all to read Section 117 as if it says that any admission to hospital would have the effect of bringing Section 117 duty to an end. But an admission to hospital under Section 3 does have that effect. Third, Secretary of State objects that our submission based on the passage from CXF is wrong because that must mean that a person who is admitted to hospital for any reason, even short-term voluntary admission, is receiving care such that they don't need aftercare. See paragraph 86 of the Secretary of State's case. Again, that is simply wrong. Despite putting in a lengthy footnote about the definition and purpose of aftercare, Secretary of State neglects to mention the relevant statutory definition in subsection 6. If a person is admitted to hospital for a hip replacement, for example, they are receiving care connected to that operation. That doesn't logically preclude aftercare in connection with their mental health. Similarly, if they're admitted to hospital under Section 2 for assessment, necessary for a short period of time, that doesn't preclude them from receiving aftercare for the purposes of reducing the risk of being admitted for treatment. Many people who are detained under Section 2 for assessment are assessed as satisfactory and released within a very short period of time. But if they are admitted to hospital, for instance, under Section 3, with the heading admission for treatment, then it makes no sense whatsoever for them to be entitled to aftercare treatment that has the purpose of reducing the risk of that person requiring admission to hospital, again, for treatment for a mental disorder.
I suppose that may depend on how long they're detained for. Because as you say, it may not be 6 months.
My Lord, I quite accept it may not be 6 months. If it's likely to be a short detention, Section 2 tends to be used. If you get to Section 3, people rarely come out in 1 or 2 days or even 1 or 2 weeks. It is very common for people to be detained for years. But I quite accept it doesn't have to be 6 months. It is up to 6 months, and it is sometimes shorter than that, albeit not that often. My Lord, yes.
I'm just thinking aloud. So if you had a situation where somebody was, say, receiving aftercare services and then received a lengthy prison sentence, then if the aftercare services were going to end in that situation because it just didn't make any sense for them to continue, would that be by virtue of agreement under subsection 2? I think
there would need to be a decision there because the imprisonment itself wouldn't bring the duty to an end unless it were. There may be certain sentences of imprisonment which are to a hospital, and that may.
Yeah, I wasn't thinking.
Bring in some of the provisions referred to, but it may be that individual still needs aftercare whilst detained. I simply don't know.
Yeah, but in practice, it would become a responsibility of the prison service to provide him with adequate medical care while in prison.
Yes, but that is so. But there may be that they may work with people outside the prison medical service because you've really only got primary care within a prison medical service. So they may be working outside that with CCGs to provide care. So in reality, the fact that someone's in prison does not necessarily mean that the aftercare comes to an end. But of course, it may do. But there you would need a decision pursuant subsection 2.
Apart from death, I mean, a variety. I mean, extradition, personally, is another possibility.
Yes, my lord.
Or the expulsion, the deportation of unsuccessful asylum seekers.
Yeah.
And so there must be many situations.
Yes, precisely, my lord. My lord, that leaves my final section, which is the practical policy matters. I need to address this because both the Court of Appeal and the Secretary of State have made a lot of points about it. But our primary case is on the wording of Section 117. I've already given you a sneak preview of what I want to say on this. So the Court of Appeal policy reasoning is at paragraphs 55 to 56, which is page 233 of the bundle. And my lords, I think it might be useful if the court reads 55 to 56 to themselves, because that sets out the policy practical difficulties that were said to arise if we were right. Now, my lords, the situation that so concerned the Court of Appeal has been the reality on the ground for many years and since at least 2011. It is the status quo, and as I've already flagged up and you've noted, it's been the position set out in the Respondent's own statutory guidance from at least 2011 onwards. And there is guidance, as this court may be, I'm sure, is aware. This is statutory guidance which local authorities are required to act in accordance with. So if this interpretation were causing any practical problems, they would have become clear by this stage. But there is no evidence before this court or any other court that suggests that our interpretation does cause practical problems. My lord, I of course accept Lord Reed's point that the guidance is not something that can help construe the statutory provisions. The only point I would make is it throws light on how the position was understood to be before this case. See the South Bucks and Porter case, paragraph 17, which for your note is page 516. My lord, you will note that in the Secretary of State's first determination, there was no concern raised in relation to this. It wasn't a point taken. This was not a point raised by Swindon either. This was a point taken by the Secretary of State on review. Now, in a footnote in our written case, we say it's doubtful that the proposition that is being appealed, the Secretary of State had the power to determine, because his power concerns disputes as to ordinary residents. But let's not worry about that. We are where we are. But the point is, didn't concern the Secretary of State initially, and there is no evidence of problems. The Secretary of State was a party at first instance. You have an opportunity, of course, to file witness evidence. If there was witness evidence to support problems with our interpretation, that would have been filed. It wasn't, my lord. So any suggestion that our position is somehow unworkable, we say, is nonsense. You do have evidence from mind.
Paragraph 56 seems to beg the question, really, because whoever's doing the work during the preparation during detention will need to be the person who's going to be responsible on release. And if you're right, then it won't be Worcestershire.
Yes, my Lord. Actually, when we come to Professor Clement's note on this, the reality of the situation is it's probably Swindon whether we're financially responsible either way.
Right.
Because that's the way things work. If you've got a social worker in Cornwall and someone living in Northumberland, it's the local. The payment is still Cornwall, but the actual on-the-ground operation is in Northumberland, my Lord. Can I just ask you briefly to turn to Mind's legal submissions, which is page 198 of the bundle. Page 198, paragraph 13 and 14 of the submissions. We say what is said here is broadly supportive of our interpretation. It only goes so far, I quite accept. But we are in situation 13C, and Mind say, absent any other consideration, Mind submits that the Supreme Court might consider the arguments in favour of the responsible aftercare body changing as a result of hospital readmission are stronger in relation to the third category. That's our category. We say on our case on both grounds, there is no change in categories A and B. It's only C, and Mind are supportive of that. If Mind was concerned about continuity of care issues, they would have made that clear, because that's really what their role is, to act as an advocate for people subject to these detentions. So we say, we're not saying this should determine the case, but we can meet the points being made against us on this, and to the extent that you need to consider policy and purpose, it's supportive of our case.
Can I just try and tie down what this continuity of responsibility idea actually is? As I understand it, it would be that the authority that has first been, in a sense, involved following a detention will have dealt with the problems of this particular individual, and there is therefore historical understanding about this particular individual. Now, one might say that that sort of information is important for dealing with this individual properly in relation to subsequent detentions. So there's a historical continuity of record in relation to this individual case. I mean, what do you say about that?
Well, my Lord, I don't think there's any evidence that the fact that local authority A may have had a record means local authority B can't get access to that record. Local authority B, he's in their area. As Professor Clement suggests, the normal course is when they're in local authority B's area, they are going to be dealing with people employed by local authority B, and as we saw, prior to the second detention, it was an employee of local authority B, Swindon, who assessed him and concluded that he should be detained pursuant to section 3. So I don't think it causes any problems. There's no evidence it has caused any problems. I understand your point, but basically the record is transferred and there's liaising between the two.
Okay, so you say there isn't really a continuity of responsibility or
what we're
problem because the subsequent authorities would inevitably have those records transferred and therefore be in as good a position as the initial authority to understand the needs of this particular individual.
Yes, and in reality, they are likely to have been looking after the individual prior to the
people on the ground anyway. All that happens is that different persons picking up the tab.
Yeah. It's essentially continuity of financial responsibility here.
So there isn't going to be continuity of care come what may.
Pardon, my Lord?
There isn't going to be continuity. It's not going to be the same social workers come what may, by the sound of things.
Well, he's been living in Swindon, so it's likely that he's going to be having sort of personal contact with Swindon on behalf of and funded.
If somebody even had been detained in Worcestershire and was initially being looked after by having aftercare provided to him by people employed by Worcestershire Council, if by the time he's released from a second detention in Swindon, he requires aftercare, it's not going to be provided by people commuting from Worcester.
No, my lord. No, my lord. I've got 4 minutes left, and I've got 2 points I'd like to make, my lord. The second key problem with the Secretary of State and the Court of Appeals analysis is local authorities are entirely familiar with the planning for Section 117 duty that is triggered by a person leaving hospital. At paragraph 42 of our written case, which for the court's notice, page 127, we cite two 20-year-old authorities that make clear that Section 117 includes an implied power for the relevant authorities to make preparatory aftercare plans prior to the individual ceasing to be detained and leaving hospital. So in this situation, Swindon, although under ground 2, their duty crystallises on his departure from hospital, they have a power to do aftercare planning, and that's how it operates for the last 20 years. There is no problem.
Just give me the paragraph number again.
It's paragraph 42 of our written case, page 127. There's 2 cases cited, and it's common ground those 2 cases accurately reflect the law. Secretary of State, paragraph 12, page 162, says that's common ground. So it's clear that local authorities are obliged under Section 117 to use reasonable endeavours to prepare for persons discharged from hospital, and practically they are familiar with using this power. Cases are 20 years old, nothing uncontroversial, it's settled law. My Lord, there's also paragraph 82 of our written case.
Thank you.
Page 138 on this point. And then my final point in my final 2 minutes, third key problem is that to the extent that it's legitimate for the court to engage in such policy-based reasoning, practical considerations favour our interpretation of Section 117. In order to provide a suitable and high-quality mental health-related aftercare services to vulnerable people who have been released from hospital, it is preferable for those services to be provided by the local authority. I have 3 points on this. They will have better relationships with the medical staff at the local hospital. Secondly, they will be better placed to cooperate with the relevant voluntary agencies as required by Section 1172. They will know who those agencies are. An authority that may be the other end of the country, far less likely to have those relationships with voluntary agencies.
As you said, it doesn't work that way anyway. It's always the local authorities.
No. Yes. And can I just, a final point, take you to the article by Professor Clements, who obviously writes the leading text in this area on community care law, which is page 1093 of the bundle. And this, Professor Clements' article essentially makes the point that the court's already got. On page 1093, he quotes from Lord Justice Coulson's judgment talking about the policy that supposedly supports their conclusion, to which Professor Clements says, one wonders if this analysis really stacks up. It is not improbable that the joint mental health team in Swindon was coordinating, leading extensive planning at that time, and quite possibly merely keeping Worcestershire informed. If JG is going to remain in Swindon, is it really sensible for her care to be managed by a distant council? So the point made by the court, we say, is right. My Lord, my time is up. Unless there are any further questions, I will sit down, shut up, and then you can hear from Mr. Bewley. Casey.
Thank you very much, Mr. Charlotte.
Thank you very much, my Lord.
My Lord, I'll just take a moment to step up. I hope I've managed to get these microphones working. No lights are coming on. Can you hear me?
Well, it's really a matter, it's not so much for us to hear you, but for you to be picked up by the broadcasting. Because
Well, if someone who thinks I'm doing, I'll be told. I'll take it that I can be told if I've got it wrong. Okay, I'm grateful. Thank you. So, my lords, there are two issues, obviously, in the case, the appeal and the cross-appeal. Not surprisingly, I'm going to deal with the appeal first and then address you on the cross-appeal. I anticipate that the appeal will be before lunch and the cross-appeal after lunch. That's the plan. So, taking the appeal first of all, then, the overall question on the appeal is whether the Secretary of State and the Court of Appeal were correct to hold that when JG was detained on the second occasion, up to and including her second discharge, WBCs, as I shall try to remember to call them, duty under Section 117 continued to subsist because it had not taken steps to satisfy itself that she was no longer in need of services. I say it, like my learned friend. I recognise obviously there's a CCG involved here, but we're not going to focus on that aspect. And accordingly, that duty continued to be owed after she was discharged. The resolution of that issue by this court will involve the court in considering and choosing between, in fact, three separate constructions of the legislation. So that favoured by the Secretary of State, which I won't repeat because you're fully alive to the basics of it for now, and the two alternatives advanced by my learned friend. And as my learned friend points out, his two alternatives, and indeed all three constructions, are mutually exclusive. So to that extent, the reasons for adopting one are inevitably the reasons also for rejecting the others. But obviously one needs to look at them all. So with those thoughts in mind, the way I propose to develop my submissions are as follows. First of all, to explain and develop the Secretary of State's positive case on what the correct construction of the legislation is, because we've only got one. Secondly, to seek to answer the appellant's specific criticisms of that approach, at least insofar as they're general as opposed to arising from the specific grounds of appeal. Thirdly, to deal with ground one, and fourthly, to deal with ground two. That's the programme. Dealing then with the Secretary of State's approach, I'm going to come to the wording of the legislation in a moment, but you've seen it sufficiently that I'll just set out the basic approach first and then come to it in a moment. The Secretary of State's basic approach is set out, I'm so sorry, I thought I'd opened the page and I haven't, but it's at page 168 of the core bundle in paragraph 46 of our written case. We say, having referred to sections 117.1 and 2, we set out four propositions. So we say as follows. First of all, what subsection 1 of section 117 does is sets out the preconditions, 2 or 3, I'll come back to that, but at any rate we say 3, but it may not matter. 2 or 3 preconditions for section 117 to apply, and I think the court has understood why I emphasise that word apply in contradistinction to whether duty is triggered or anything like that. That's the first element, that's subsection 1. Subsection 2 then provides first, because subsection 2 does two different things. Subsection 2 provides first that the section 117 duty is owed to any person to whom section 117 applies. So the question of the duty being owed is treated as a separate matter from the section applying. Thirdly, subsection 2 then also provides for the circumstances in which the duty is terminated by providing that the duty shall subsist until the relevant bodies are satisfied the person no longer needs the services. And fourthly, if I don't need it, as so analysed, subsections 1 and 2 are exhaustive both as to the circumstances in which the duty will arise and as to the circumstances in which the duty will terminate. And the basic reason, certainly on our analysis, for putting the case in that way and for analysing the section in that way, we say, is because that is what it says. We say that is what you get clearly from the language of the section. And, I note, I won't go back to it, the Court of Appeal agreed. So, with that thought in mind, can I then go to the legislation? But in particular, it's helpful in my submission to go not straight to section 117, but to its predecessor, which is generally, I think it's common ground. The adoption into the Mental Health Act didn't change the meaning, which is section 51 of the Mental Health Amendment Act 1982. We have that. I'm not sure if you need it, tab 22 of the authorities, but it's electronic bundle 339. And it's very striking because it breaks things down in a way which, if anything, makes the position clearer. So if the court has page 339, so subsection 1 does effectively what subsection 1 does in section 117. This section applies to persons who, and then you've got a series of provisions set out which are the analogues in broad terms of the section 3 and so forth, so I wouldn't go through them. But note the wording, having been detained. It's completely clear there that it's a matter of past. You have to have been detained, but that's not enough for the section to apply, and indeed in general, in many cases the section won't apply to you if you're still detained. So, first condition, having been detained. And then we read on quite a long way because of all the different provisions. 2, cease to be detained. And 3, leave hospital. So there are, in fact, 3 preconditions, not 2. And if there's any doubt about that, you can see it on the very facts of this case. Because JG, and we get the dates from the SFI, but I'll just tell you the dates. JG is detained for the second time on the 23rd of June 2015. Her detention under Section 3 is brought to an end on the 12th of November 2015, but she is not discharged from hospital for another 2 years or so, 9th of August 2017. And no one says, subject to issues about whether it's duty, no one says that the second duty, if it arose, was triggered before August. So you have to satisfy all 3 preconditions. Maybe a matter of dancing on pins slightly to say there's 3 preconditions, or 2 and the second is a composite. It comes to the same thing.
Can't make any difference.
Can't make any difference. You've got to satisfy all 3 bits anyway. Exactly right. Exactly right. But the simplest way to think about it is the 3 things. There are 3 things have got to be true of you. You've got to have been detained. You've got to have left hospital. Sorry, you have to have ceased to be detained, and you have to have left hospital. And it's when all 3 preconditions are met that the section applies to you or to an individual. And it's clear in my submission, it's particularly clear, although I make this good when we come to the slightly different wording 117, that they are one-off matters to be satisfied at a moment in time. So having been detained, well, I suppose that can be over a period, but it's past, it's expressly in the past. Cease to be detained, well, you cease to be detained at a moment in time, and you leave hospital at a moment in time. Once you've left hospital, you have satisfied that condition, not because you continue to be leaving hospital, but because you have left. But it's put in the present tense. That's subsection 1. But the other thing that's striking in my submission, or helpful, about this version, the section 51 version, is that the next 2 bits are broken down into 3 subsections, which makes it particularly clear. So subsection 2, it shall be the duty of the district health authority, obviously the names of these bodies have changed, and the social services authority, to provide aftercare services for a person to whom the section applies. That's effectively the same wording, but it's standalone. I don't think there's any dispute about what that means. But subsection 3 is crystal clear in my submission. The duty laid down by subsection 2, so that's section 1, what we call now the section 117, shall continue until ... the relevant bodies are satisfied. So in my submission, that language is particularly clear that Parliament has provided for the 3 things. The circumstances in which the section applies, exhaustively, the circumstances in which the duty is owed, and the duty arises, the various different words used, time to time, and the circumstances in which the duty will terminate. And that is therefore the clear effect, subject to some overriding or very compelling reason, contextual reason, we'll come on to what that might be in a minute, what the requirements are, to say otherwise, to construe the section in the way that Secretary of State does. In other words, you have to in other words, we've got exhaustive of the circumstances in which the duty terminates. Now, I accept the point about death, by the way. That's obvious. But of course, Parliament didn't have to say anything about death, because in the case of death, there is no person to whom the duty is capable of being owed. It's as simple as that. So now you can't say that about a person who's been redetained. There may be other things. I'll come on to the points about purpose under section 1176 and so on. But you cannot simply say there is no person to whom the duty is owed just because that person has been redetained. Whereas, of course, in the case of death, you can. That's the simple reason why Parliament doesn't need to spell out that exception. So that exception I accept to exist, but it's not, as it were, a problematic counterexample to my basic case, which is that this is otherwise exhaustive. So that's what the words say, which is normally the critical starting point in construing legislation. Let's just, if I may, I'd ask you to turn now to the next tab, page EB 342, where we can see the section as it's originally enacted. It's easier to look at, apart from anything else, it's easier to look at the original enactment just because you've got less extraneous wording to kind of discount about local health boards in Wales and so forth. So if we turn to 342, a couple of changes, none of them of substance. Subsection 1 is broadly the same, but what has changed is a point that I think my learned friend makes something of, which is that it's now, in terms of detention, it's now in the present tense. So this section applies to persons who are detained, it now says. And that wording might be thought to be a little bit problematic, because how does that work? I mean, the one thing it plainly doesn't do is people, or doesn't initially, you don't get it just because you are detained. Indeed, you have to have ceased to be detained. That's a precondition. So they can't all be true at the same time. So that must be in the past tense, notwithstanding the use of the present tense, consistently with the earlier section. But there is a subtle additional change in the wording which makes that good, because if my lords look at the last line of subsection 1, as it appears here, and this remains, the word then has been added. So compare section 51.1, cease to be detained and leave hospital. You don't have that additional word then. But in subsection 1 of section 117, it's the three, you are detained and then cease to be detained and leave hospital. So it's perfectly clear, notwithstanding the use of the present tense, which is a bit awkward, is intended to be in the past tense. And again, the points I've made previously, therefore, all good. They are matters to be satisfied in the past. Once you satisfy them, unless the application of the section has been brought to an end by the operations of subsection 2. Subsection 2, again, I'm looking at it in this original version. So it does the same things, but now you've got a concertinaing of the two subsections. So it shall be the duty of the relevant bodies, etc., to provide the aftercare services, ... until such time. So again, reading it, especially with section 51 in mind, it is in my submission clear language. It shall be the duty of these bodies to do the relevant things until, and no other circumstances are provided for. And in my submission, that is just clear language. I'll come to deal in a moment with my learned friend's two duties point. But that aside, in my submission, it doesn't, and also, I suppose, possibly the subsection 1 point, but those points aside at least, he doesn't identify any linguistic answer to our construction, which is very simple. I'm in danger of labouring the point. You ask whether the section applies. If it applies, the duty arises. And if the duty has arisen, it will only end in the circumstances set out in subsection 2.
On your case, if the section applies, it can never cease to apply, and
no,
that seems slightly odd.
Well, I accept that it does cease to apply when the duty has been brought to an end in accordance with subsection 3.
Oh, do you? I thought your analysis was that that the duration of the duty was separate from whether the section applies, and that all that section 2 does is say that the duty ceases. No. But that the section is always applicable once it's...
because, I mean...
First applicable when it's applicable, then forever applicable.
I obviously, for the reasons my Lord raised in argument, I obviously have to accept that a person who... I mean, because otherwise you'd end up in a situation where the duty's been brought to an end under subsection 2, not this case. Then, you know, a year or so passes, and then the person is re-detained, and on this analysis, they wouldn't get any more aftercare services, and that's not a result which Section 8 would contend for or accept. So I accept that. It is implicit that once the duty triggered by the application of the section has been brought to an end, then the section has thereby ceased to apply. That's implicit. But I don't accept that that involves reading in words or anything like that. It's just an obvious implication of the fact that a decision has been taken that the person doesn't need the services. It leaves you free to ask afresh whether the duty arises again, because the relevant preconditions are again satisfied.
But it creates the possibility that the section might cease to apply for some other reason.
So I've probably been very dense, but...
Well, no, I mean, you're accepting that there can be circumstances in which the duty, once it applies, may cease to apply.
Well, I am, but I'm saying that that's...
You're saying they're limited in Section 2, but it's not a necessary feature that of the application of the duty, that's the only way of ending it.
It slightly mars the purity of my submission.
It means there's a temporal element to the application of the duty. And under the pure version of your case, there's no temporal element. Yeah. Once it's in existence, that's it.
I accept that it mars the absolute purity of the submission which I might otherwise have made, which is, you know, once you've met it, and that will be very logical. One can see why that's very logical, doesn't produce a very acceptable result.
Could you just explain again why? Sorry, I missed the point as to why you accept that could create a problem.
So it wouldn't. So on the facts of this case, it wouldn't create. I mean, it might create some problems, but it doesn't create a disastrous problem.
No.
Because in JG's case, the duty wasn't brought to an end before the second detention. But take the case where someone is detained for the first time. They are then receive Section 117 services. It may be they're perceived to have, or they have actually improved to the point where the authorities make a decision they no longer need the services, and so bring them to an end.
Yes.
So they're not entitled to services as a result of that first detention anymore.
Yeah.
Perhaps a year passed, perhaps 10 years passed, who knows? They are re-detained because they have another deterioration. And then they're likely to again need the services. So that's what it would be unacceptable to say that because Mr. Bewley's argument that...
I see in that event, if they previously met the conditions, and if you were saying they forever did, then every time in the future, whenever they came back into hospital, it would still be the first authority.
Yeah, that's right. So it's implicit that and to this extent, something not made completely express in the section, I accept that. It is implicit that when the authorities take the decision under subsection 2 that the person no longer needs the services, that not only means that the duty ends, it also means that the section has ceased to apply. I accept that. I accept that. And as I say, I accept that slightly mars the kind of absolute purity of the submission I might make. But it is otherwise, I mean, I do say you can infer that's just obvious, because what you are doing is expressly limiting the circumstances in which the duty comes to an end to the precise circumstances that Parliament did expressly provide for in subsection 2, i.e. when it's decided they no longer need the services. Whereas what my learned friend is doing is, in my submission, much more radical than that, because he's not only saying that the duty can come to an end in this rather theoretical point about application of the section opposed to the duty, he's saying that there are circumstances in which the duty itself can come to an end outside the circumstances in which Parliament expressly provided for. In other words, Parliament, I suppose I can put it this way, Parliament didn't realise that it was necessary, not knowing that this case would reach the Supreme Court perhaps, to spell out that once you've decided that the duty is no longer needing to be met, the section has also ceased to apply. That's the limit of the implication that I'm inviting you to make. So as I say, in my submission, the construction which we invite you to adopt flows directly from the express wording of the section, or at any rate allowing for the point that's just been made, is much, much, much closer to it than any other construction before the court. Because what my learned friend is asking you to do under either ground is ultimately to infer that there are circumstances other than those for which Parliament has expressly provided where the duty can come to an end, and that's a much more radical case of reading words in or doing something Parliament hasn't envisaged.
So you say the duty to provide aftercare services continues when a person is compulsorily detained under subsection 1?
Yes, I say that the duty to provide aftercare service, well, I want to be it's important to be careful about this. I'm not saying it will always endure or endure forever. The position is much more modest than that, because I very well recognise that there will be cases where it's rapidly obvious, the person's going to remain in detention for quite a long time, and it's obvious, or at any rate a decision can rationally be made, that the person doesn't need the services to be maintained in the meantime. There's nothing to be done.
But the argument against you is it's inherent in the nature of aftercare that it cannot be required when somebody's having treatment, because its whole purpose is to prevent that situation.
Yes, I understand that, my lord, and I appreciate that.
Using the word after.
Yes. Yes, well, I understand that, and I'm going to come to that. And that's really the ground 2 argument, actually, I think.
It is, yeah.
Not the ground 1 argument. I think I need to address both, but I'm going to come on to that in a minute. But can I just invite you to reflect for a moment? And obviously, as I hope I've made clear, our argument depends on the wording of the section. And, never mind this point for a minute. That's what the section says. What is the practical consequence of that? I don't want to say you should adopt this approach to the section because of these consequences, because it's not our case that at any rate, it's not our case that all of the alternatives are absurd. Ground 1 comes closer to it. I'll say why in a minute. It is very modest. It is simply that the basic consequence is that when a person who is being provided with Section 117 services is redetained, the responsible authority is required to address their mind for that person's circumstances and make a decision rather than, as it were, it's my phrase, forgive me if it's a little bit of a jury point, but as it were, just wash their hands of the person without even thinking about it, which may have been what occurred here. But
well, the other way of looking at it is there's no need for a decision because it's automatically
that becomes
it's unnecessary.
I understand that.
No decision.
I know that's the point that's concerning my lord.
It is, yeah.
I know that.
I know you've still got to deal with ground 1, but
yeah. But can I then just invite the court just to reflect for a moment then on what the range of circumstances in which a person may be redetained, because it's quite important at this point. Because as I've just accepted, I completely accept there will be cases where a person has been redetained for the second time, and they're going to be I've seen a case when the second detention was for 10 years. It could be for longer, who knows? It may, in any event, be for a year or 2 years, and it's not necessary to maintain the services. But there clearly will be cases, and this case is arguably one of them, although maybe it's on the borderline on the facts. It's 4.5 months, roughly speaking, she's redetained, where it's reasonably apparent that that's not going to happen, and that immediate steps need to be taken for the planning of what happens next. And in particular, and indeed it's possibly in the extreme to imagine, that there will be cases where the reason that a person is redetained on the second occasion is not so much because they've suffered a deterioration, or not at any rate primarily because they suffered a deterioration which they would inevitably have suffered, but because the very services they're being provided with under Section 117 are not properly meeting their needs. So the reason they end up going back into redetention is precisely because there's a problem with the services they are being provided. Remember, those services, back to the purpose of Section 117, those services are provided for the very purposes of avoiding a deterioration. So it must be the case that there will be cases where it's not being done right, and it's not a criticism of authorities, it's just a practical reality. Now, in that situation, in my submission, one can readily see why an authority who's been responsible for planning the services that the person was getting can rationally and in accordance with the purposes expressed under section 1176, which we can look at more precisely in a moment if necessary, can rationally conclude, should rationally conclude, that the right thing to do is to maintain the services in place and make immediate plans for how those services should be rearranged, repackaged, tweaked, whatever it may be. And there will be cases, and again, this case is not necessarily a million miles from it, but we don't have the underlying facts in any detail. It's 4.5 months, so it's well under it's certainly under the 6 months. There will be cases where people come in to a Section 3 detention for a second occasion, and it is relatively short because things have gone wrong in the community. And it is in my submission, perhaps we should look at the wording of subsection 6 now. So, tab 24, the modern version of section 117 starts on 357, but in fact subsection 6 is at the bottom of page 358. Court has that. So in this section, aftercare, and remember this is a bit of a side point, but I think it's worth making. This subsection is interpolated, is added well after section 117 is first made under the 1983 Act. I've forgotten the exact date.
But as I understand it from reading one of your case of one side or the other, it gives effect to...
It is thought to give effect... No, I see that, but it's thought to give effect to the purposes discerned by the courts, but it means that one's got to be a little bit careful about picking up too much on the precise wording.
Well, this is the section as it exists. This is the section we are dealing with.
Yeah, but you've got to construe...
We can't construe it, as it were, as if that bit wasn't there.
I accept that, my Lord, and I don't want to labour this point too much, but the question ultimately... No one, I think, suggests that on this question of how you terminate support, that section 117 has changed its meaning since between 1983 and the present day.
No, I think so subsection 6 must be taken to spell out what it always meant.
Yes, that's all right. But by judicial, as it were.
Well, never mind. But yes.
Okay. Well, anyway, as I said, it was a side point. But subsections in this section, aftercare services in relation to a person mean services which have both the following purposes: meeting a need arising from or related to the person's mental disorder. Well, in my submission, no problem about that, in terms of the person who remains in detention. B, reducing the risk of a deterioration of the person's mental condition, and accordingly reducing the risk of the person requiring readmission again to hospital for treatment of mental disorder. Now, I think the point against me, put it its sort of strictest, is, well, once you're in hospital under Section 3, you cannot, logically, meet that. But in my submission, it's entirely open to, and I'm going to come to what my Lord said in CX in just a moment. I appreciate I need to come to that. It's entirely open to certainly it must be open to an authority in the sort of circumstances that I've laid out, where there may be reason to think, well, put it like this, where the reason for the person's readmission is arguably related to the adequacy of what the support they were getting in the first place, and where it's reasonably anticipated that they can be released within a short space of time, to say that you can, consistently with that purpose, start making plans for the future about what happens when they are released. Now, with that in mind, if we get...
But that's not providing aftercare services. That's planning to provide aftercare services that may be needed in future.
Well, no, my Lord, because the planning is included in the aftercare services. I mean, in my submission, planning the services is something you would do from time to time. Even once the services are being provided, you have to make decision-making about what services are needed, how to tweak it, and so forth. All of that comes within. It's not an add-on. It's not something apart from the service. It's part and parcel of the statutory power to provide services. So the services you provide to the person includes the planning of the assessment of their needs and the planning for how to meet those needs, in my submission. I know that there's the cases which say that there's an implicit power before the duty is engaged to make that planning, but that doesn't mean that you don't need, once the power's engaged, you don't need that implicit power. It's all within my submission, within section 117. Can I go to CX, which we've got slightly ahead of where I'd planned to, but we're on the topic, so let's do it.
That's no bad thing.
Sorry?
You don't need to apologise.
No, well, I've
a rapid
it's an observation rather than an apology. My lords, it's tab 45, it starts at 776 electronic bundle. It's probably just worth turning up the head note for a moment.
Just give me the page again, please.
776, my lord.
Thank you.
And I just want to note the basic facts in the head note. So, the claimant was detained in hospital under Section 3 of the Mental Health Act 1983. Every day, the claimant's responsible clinician granted him leave of absence from the hospital pursuant to Section 17(1) of the Act, so that he could go on bus trips escorted by members of hospital staff. Once a week, the claimant's mother accompanied him on the bus trips. Those are the very basic facts. We don't need to get very much into them more. My lord may remember them, or I may not, I don't know, but anyway, they're set out there. And so what's being said is that it's those day trips under leave of absence, which or rather payment for the mother's travel expenses so she can accompany him on those trips, in fact, which constitute the provision of aftercare services. And what my lord decided was, first of all, that in a case where you're given leave of absence on a daily basis, so and you distinguish the position, it's in paragraph 39, you distinguish the position which might arise if someone's given leave of absence to live in the community. But at least where you have leave of absence on a day-to-day basis, you simply haven't ever left hospital in the relevant sense. I think at one point the phrase is, you leave the hospital, but you don't leave hospital is one way of putting it. So that doesn't constitute leaving the hospital, and so you don't meet the preconditions in subsection 1. And for that reason, no entitlement to aftercare services arose. The additional point you made, we've looked at paragraph 38. Can I suggest we look also at paragraph 43, which is on 788? Perhaps the court could just read that, actually.
Which one? 788?
So paragraph 43, page 788.
Thank you.
And then I think, sorry to add, and then the first sentence of 44 to complete the picture. The first, yeah. So the conclusion, if the court is happy for me to continue, the conclusion that's reached is that you don't have aftercare. In those circumstances, the thing that's being suggested, A, he's never left the hospital, but B, that things being provided would not constitute aftercare services in that case anyway. But that's in a context where, so far as appears, there's no suggestion that actually he's going to leave hospital in the near future in any event. So there's no expectation of him leaving hospital, nothing to plan for. And there is, and the particular services which are said to constitute aftercare services amounts to paying for his mother's travel expenses. And that's the context in which my lord says it would be completely unreal to say that constitutes aftercare services. But in my submission, that, and what your lordship also says in paragraph 38, does not preclude an authority in the circumstances which I've outlined from concluding, indeed it would be the right thing to conclude in the right case, that in a case where what's happened is someone's got a relatively short-term readmission to hospital, that they continue to need the involvement of the local authority as well as the hospital, precisely to ensure that the services will meet the purposes in subsection 6. And I do respectfully say it would be very unattractive to say, I don't want to labour this point, it's not about policy, it's about the wording of the section, etc. was very unattractive to say that in a case where actually what's happened is that the relevant local authority has fallen short, as it were, not necessarily through its own fault, but at any rate the services it's been providing haven't met the person's needs, that's why they've been redetained. Very unattractive to say in that situation that they cease to that effectively the redetention brings their duty to an end and some new authority steps into their shoes. And to take also the point about continuity of care...
So, I'm sorry, so you're saying that if one adopts that construction, it means that negligent local authorities will be let off the hook?
Yeah, I mean, I don't...
Point?
Yeah,
it does seem a rather minor point, really, doesn't it?
Yeah, I'm not talking about negligent local authorities, really. I'm not. That's a speculation.
Yes.
But in a case where, through negligence or whatever, the authority, or simply because they...
It seems a very special pleading. I mean, there are all sorts of reasons why people's mental health deteriorates, and it's absolutely impossible in most cases to determine precisely why.
Absolutely, my lord. And at this point doesn't... I mean, again, I just asked the court to come back to this, the basis of the submission we're making. We are not saying that in all cases it will be... We're absolutely not saying in all cases it will be appropriate to continue aftercare services for a person who's detained. We're saying that will be a category of case where it may be proper and rational to do so in accordance with the conditions under subsection 6, and that in those circumstances, and for that reason, it is an entirely benevolent reading of the subsection, of the section, to construe it as requiring a conscious decision by the authority, rather than the circumstance where... So they address those circumstances. They address the circumstances, apart from anything else, which led to the recall. Not because they're at fault.
But, I mean, if the correct construction of the section is that the duty becomes that of, in this case, Swindon, then they're going to have to address these issues, aren't they? So it's not from the patient's point of view. These issues will be addressed.
They will, but they'd have to come to it afresh. They come to it fresh, and they come to it...
When you say fresh, we've had discussion here. I mean, they've actually been heavily involved. Yeah.
Well, they may. We don't know that on the...
We don't know on the
We don't know that. They come to it, but also importantly...
Well, the Secretary of State, I mean, this is the Secretary of State is here, presumably because this is a matter of public importance.
Oh, Lord, yes.
And the Secretary of State should not responsibly be asking us to proceed on a nonsensical understanding or an incorrect understanding of what actually happens. I mean, are you seriously wanting us to proceed on the basis that troops of social workers commute from Worcester to...
No, absolutely not. No. Well, I was going to... When one talks about continuity of care, I mean, it's absolutely right. The people actually providing the care on the ground are not the local authority social workers in any event. Absolutely not. But there will be people in the local authority who are responsible for making decisions about authorising, about tweaking the plan, matters of that kind. They will have a degree of institutional knowledge of what's going on. Absolutely not. No one's commuting. I don't suppose even that in most cases it's local authority employees providing the care, because these things these days are normally done in arrangements with other agencies, of course. No one suggests otherwise. And indeed, it's perfectly possible, whatever conclusions you reach here, the identity of the persons providing the care will not change, and it's perfectly possible that they will change regardless of which authority is responsible. So, and it may not be affected by it, frankly. Maybe it's often going to be a matter of who's actually available and who's got a bed and matters of that kind. I don't think I've ever suggested otherwise, my lord. But there is, again, I don't want to overstate this point. I mean, if you conclude that there are no circumstances in which an authority could rationally say, this person's been redetained for a short period, we think it's appropriate to maintain the provision of services and start making plans for release, then I'm probably going to lose, I think it will be ground 2, not ground 1. If you go so far. But my submission to you, and possibly, until I think in this court, possibly today, I didn't understand the point to have been put that high. Provided that there are circumstances in which it is rationally open to an authority to conclude that it's better to maintain the services in place, rather than terminate them and let someone else start again, then in my submission, it is, for what it's worth, it is I suppose there are two stages. It's an open construction of the section. It makes sense of the section. Doesn't lead to a nonsensical result. And I would take the further step of saying it's benevolent construction. But again, I'm not inviting you to adopt this construction because it has beneficial consequence. We never have. I hope we've always made that clear. We're inviting you to adopt this construction of the section because the language is ultimately clear.
I think the difficulty I have with this is looking at the definition of aftercare services.
Yes.
They do seem to be services which are provided when the person has been released and has left hospital.
Well, in practice, the majority of them will be. But this is why it's quite important to think about the position under Section 2. And there's a purpose point under subsection 6. Think about the position under under Section 2, I should say, of the Mental Health Act. Now, as the Court is, I think, alive to, this is detention for assessment, admission to hospital, detention, mandatory, for assessment as opposed to treatment. It's a shorter period. Critically, doesn't give rise to any new entitlement under Section 117. And in our written case, we've quoted from the Mental Health Act Code of Practice, and I understand it to be common ground that the services don't come to an end just because a person is redetained under Section 2. But as to the practical point, the position will be the same under Section 2 as under Section 3. Undoubtedly, for the period of the detention, whichever provision it's under, the person will be being provided with their day-to-day care needs. They'll be met, those needs will be met, by the hospital. So what is there left to do for the local authority under Section 117? Answer, make plans for the future. In practical terms, it's the same. There's no distinction.
Well, I'm not sure. I mean, on one view, it may be that they can't actually provide aftercare services while a person is detained under Section 2, but that they might decide, but it would be conceptually possible for the duty. It might only be in for over a weekend, for example.
It might be for 28 days.
Sorry?
Well, it might be, but it might be for 28 days.
Yes, exactly. So it might be a situation where it makes sense for the duty to be capable of continuing, but by the operation of subsection 2, it'd be open to the authorities to terminate the duty if it turns out the person's going to be.
Yes. Well, I mean, I accept that's the position, but I accept that's the position under Section 2, and I submit that that's the position under Section 3. There is no difference between them in that respect. As a matter of legal principle, there's no reason. So the point that's as I understand it, the point that's troubling the court is that you can't imagine what services, or one point anyway, which may be troubling, you can't imagine what service is going to be provided to a person who is detained under Section 3 once they're redetained effectively, because their needs will be being met. The point I'm seeking to make is that logical problem, it is a problem, is equally present under Section 2. And yet it is common ground that detention under Section 2 doesn't automatically bring the services to an end and doesn't automatically compel a decision. The authority is not left in only one a position where it can only make one logical decision, i.e. the only rational decision is that the services aren't needed. But if that's true for Section 2, it's just as true for Section 3. And the reason it's true in my submission, the reason it's true for both is precisely because Section 117 encompasses the planning of services, the assessment of what services are needed, and so on. And must do so, because certainly once Section 117 is being provided to someone in the community, everything done under section 117.
Are you really saying, well, that is something that will continue while a person is detained? I think you're saying that if the local authority has the aftercare responsibility,
Yes.
The actual delivery of the services, as it were, physically to the patient necessarily is at least suspended while they're in hospital.
Yeah, in practice, the practical day-to-day of the services.
If the duty remains with them, they remain under a duty to continue to plan for what's to happen in the future, and that itself, you say, is part of the aftercare services.
Correct. That's the submission. Okay. That's exactly the submission. Okay. And I say you've really got to, provided one accepts, which is common ground, that it's possible to continue the services under Section 2, then the same must obtain under Section 3. There's no absolute requirement by operation of law. I completely accept that in a Section 3 detention, you're much more likely to decide that it is right to terminate the services, because it's much more likely on the facts that the person is going to be detained for a long period of time. But it's a question of fact. The consequences of our submission is limited to, as I say, requiring the local authority to address its mind to the particular facts. That's the only consequence of it. That's the limit of it. So, my Lord, that has slightly taken me away from my course. Can I just...
Can I ask you this?
Yes, of course.
I mean, again, looking at subsection 6 and the words in parenthesis in paragraph B,
yes.
Reducing the risk of the person requiring admission to a hospital again.
Yes.
I mean, that perhaps suggests that if someone is detained compulsorily under Section 3 or the other sections, we've really got to look at all this again. I mean, there was a problem. We were seeking to meet the problem to reduce this risk. Unfortunately, the risk has happened. We're now into a new territory.
Well, I think my submission is that. Forgive me, I think I've lost the right page. Can I just?
I think it was 358. Is it?
I have got it.
359.
359.
Thank you. I turned to a different page. It's wrong. So the wording is reducing the risk of deterioration. Now, I'm not sure I do accept that a person will only be called back in detention in the circumstances of a deterioration, for a start. They may be recalled is the wrong word, they may be detained again because their needs aren't being met in the community, and the only option is that they are detained again whilst different arrangements are made.
But any services that aren't provided for the purpose of B aren't going to be aftercare services.
Well, my Lord, again, in my submission, provided one, this is the best I can do, so provided one accepts the submission, which for the reasons I've given, I say has to be accepted, that the planning of services, the assessment of the individual's needs and so on, are matters that fall within Section 117. They're not matters outside it. But when you provide the services, that's what Section 117, but when you work out what to provide, you're doing something else, something implicit. Then in my submission, for a person who is in detention, who it is anticipated may be released in the relatively near future. Now, what is relatively near future is a question of fact for professionals, not for lawyers, but it might be 2 months, it might be months. If it is rational for if planning is part of it, and it's rational in the case of someone in that circumstance, especially though not only if what's happened. I mean, again, I'm not imputing any fault, but especially where, as may well often occur, what's happened is, for whatever reason, the existing aftercare package isn't quite doing the job. It's entirely rational for the authority to say, we need to plan for what happens next to avoid the need for to avoid the possibility or to reduce the risk of a deterioration once the person is re-released.
The wording of B actually provides a basis for distinguishing between your Section 2 and Section 3 situations, doesn't it? Because if somebody's admitted for assessment under Section 2, they may still be steps that can be taken to reduce the risk of them needing treatment. But if they're admitted under Section 3, then they, by definition, requiring treatment.
Yes, but again, the submission is, if you can foresee release. I mean, I see that point. But if you can foresee release, then you can, consistently with the purpose. Remember, this is only a purpose. It's not a statutory limitation. It's a purpose for which the services are provided. Consistently with that purpose, you can make arrangements make plans and arrangements, actually put in place arrangements for what happens when that person is due to be released. The point I make about Section 2 and 3, I see that it's weaker in relation to the wording point that my Lord has put to me. But the point I make about Section 2 addresses a slightly different practical point, which is that it could be said, well, look, once the hospital's meeting your needs on a day-to-day basis, that's an end of the matter. There's nothing to be provided. But as I say, that must go too far, because that really would preclude Section 2, quite apart from the wording of the subsection. My Lords, I've taken longer on this than I had anticipated, but it covers ground that I was going to cover later on. The basic thrust of my point then is, look, and we've come a long way from this, but I do just come back to this and emphasise it. The language of the subsection is in my submission completely clear. The section applies, the duty arises, and the duty continues until ... a decision is made.
Well, you have to deal with the problem that another duty can't arise.
Yeah, so let me come to that. That's really great. So that's, I think, the next point. So that's ground one. Although, so I need to deal with this point. My learned friend says that this point only arises in relation to ground one. I don't think that's quite right, because although it's a problem for him under ground one as well as for me, I think he acknowledges. Actually, he said it's a critical part of his criticism of my construction. So he says, never mind ground one and ground two, the Secretary of State's construction can't be adopted because it gives rise to this impossible logical problem. Now, the court is, I think, alive to our answer to it. The answer is as follows. So the argument involves two premises. Premise one is you can't have two duties. We accept that premise. Premise two is the Secretary of State's construction gives rise to this logical problem because inevitably two duties arise. The court, I think, is alive to our basic response to that, but just to come back to it and remind you of it. So, the effect of subsection 1, then, is simply to answer the question, does the duty apply to a person, apply to a service user? And whether or not the section applies, unlike perhaps the question whether of the existence of a duty, whether or not the section applies is simply a binary question. Either the section applies or the section does not apply. So it's not, it might be possible, although everyone agrees it wouldn't arise, to contemplate, at least logically, a world in which two duties are owed. It's not logically.
When you say two duties, you mean duties owed by two different authorities.
That's not logically impossible, it's practically acceptable, but it's not logically impossible. But it's logically impossible for the section to apply twice. It's a binary question. The section either applies or it doesn't. It's as simple as that.
But it could apply for two different reasons.
It could apply
and those two different reasons might, when fed into Section 2, produce different outcomes in terms of responsibility under Section 3.
Then do the exercise under seeing how it works. So take JG's case. The section applies to her because of her first detention. Mm-hmm. It continues to apply to her, no dispute about this, at least until at least while she's on Section 117 support on following the first discharge. On this part of the case, I appreciate there's a separate argument about this, but on this part of the case, it continues to apply to her when she's redetained. and then she is released for the second occasion. So again, the three preconditions in subsection 1 are met on a second occasion. But they continue to be met. The short point is they continue to be met because of the first occasion, there's no decision under subsection 2 which takes that away. And therefore, asking the binary question, does the section apply to JG, there is no change. The answer remains the same. So nothing about our construction compels. I mean, this is rather...
Can I just ask you this? I mean, we know... I mean, you accept that subsection 3
Yes.
identifies the relevant local authority by reference to the ordinary residence prior to the second detention. You accept that?
Well, so this is the point, I think, about what's said by...
Well, I mean, supposing the duty of Worcestershire had terminated under subsection 2.
Yes, I do. Yes.
You do accept that, don't you?
Do. Yeah, and that we didn't appeal that. Yeah.
Yes. So in this case, let us assume, for present purposes, that's Swindon. You then it shall be the duty. Subsection 2. Subsection 1 is satisfied.
Yes.
JG has been detained and then released for the second
time around.
Yes.
Yes.
This was satisfied. Subsection 2. It shall be the duty of the relevant local authority to provide the care.
Yes.
Well, applying those words, the relevant local authority is Swindon.
Yes, if the earlier duty has been terminated under...
Well, no. I mean, why do you say that?
Well, because I come back to the analysis.
But you have to. I mean, that's why there are two. That's why there are two competing duties, and you have to resolve which of them is the duty which applies.
Because, my lord, the things that have been satisfied, the preconditions have been satisfied. The preconditions in subsection 1.
Yes.
Those preconditions don't go directly to what my learned friend calls the trigger of the duty. They obviously have that consequence down under subsection 2, but under subsection 1, they only go to the question of whether the section applies. So
they trigger the duty.
Well, that's the next step. But under subsection 1, all that happens is that if the conditions are met, the section applies. That's what section 1 says.
Right.
So if the section already applies, which on this hypothesis it does, so JG section 117 duty continues during the currency of the second detention. The section applies at least until the point of the second discharge. It's always applied. She's then discharged on the second occasion. Asked the question, does the section apply? The answer is yes. There has been no change. That binary question, it either applies or it doesn't, is answered throughout in the same way. And that's why you don't then have to say that under subsection 2 a new duty arises, because her status under section 1171, or under the question, does the section apply, has always been answered in the same way throughout.
But if you ask, is there a duty on Swindon under 1172 after the second release, why isn't the answer yes?
Because there's already a duty. Because the section has already applied.
So what? But if you ask, does it apply? Yes, it does.
I mean, the conclusion of that could be the second duty supersedes the first. Well, I mean, your hypothesis is the first duty continues. Well, that is one answer. Yeah. Another answer is that the second duty supersedes the first.
So if
I mean, as a matter of language, I'm not sure the text of the section really provides an answer to this.
I mean, this part of the argument, perhaps unlike the part of the argument we were having a moment ago, is pretty abstract. That's the truth of the matter. It's all about, well, a logical problem and does one duty oust the other and all the rest of it. What I am suggesting to you, what I'm submitting to you, is that there is a way of resolving. Assume we're really competing between grounds 1 and our construction and ground 1 here. The potential logical problem is, well, you've got two duties. How do you decide? The potential logical problem. You've got two duties. How do you decide between them? There are three, I suppose, ways of resolving that before the court. The first is actually the logical problem doesn't arise because of my submissions about application. Mm-hmm. The second, alternative is if the logical problem does arise, it should be resolved by the pre-existing duty
Staying on,
preventing the other one from arising. And the third is obviously the new duty supersedes. Now, but note that there's no fourth alternative. In other words, my learned friend doesn't have a solution, at least without reading in extra language to the section, which, as it were, brings the first duty to an end, other than by, as it were, just being ousted by the second duty. That possibility doesn't exist. So the submission we make, and I mean, obviously the language of the section is not completely clear, otherwise we wouldn't be here, as my learned friend points out. but the submission is that there is a linguistic route through, I submit a logically correct linguistic route through, which simply avoids this problem of two duties from arising, because it depends upon, because if the section, if there's no change in one's status under subsection 1.
Well, your status is
my status
that you have been detained for the second time.
Sure, sorry, but my status...
I find your first point, I just don't really follow the argument that there's no logical problem arises. I mean, I understand your second 2 points as to the two ways in which it can be resolved.
Well, when I say status, it's my shorthand for saying, does the section apply or not? Yeah. So, using status in that way, at the moment of discharge, the moment immediately preceding the second discharge, does the section apply to JG? Answer, yes. At the moment immediately after the second discharge, does the section apply to JG? Answer, still yes. So on the question, does the section apply, nothing has changed.
But what does change is that if you ask the question after discharge, does the Swindon Authority have a duty? Yes. Answer, yes, because it's because the person is a person to whom the section applies, maybe twice over, but the section does apply to that person. Doubly so, in fact, now.
Yes.
And then if you ask,
but again,
who's the relevant authority, then Section 3, you accept, tells you Swindon.
Yes, if the second duty arises, subject obviously to the cross appeal, then I accept it Swindon, yeah.
Well, couldn't that solve the problem altogether, that Section 3, if you've got two competing local authorities, as it were, and you have to decide which, Section 3 tells you the answer?
I don't think it does, my lord.
No.
Because it won't surprise you. Well, I'll say why, rather than just... It doesn't solve the problem
because it's still Worcestershire still fulfils that criteria as well. Yeah, okay.
So that's not. I hope that's a.
Yeah.
Before we rise, I've got the OED in front of me, and I see aftercare is defined in a way that's consistent with CFX.
Right.
Treatment, care, or support after a period in an institution such as a hospital or a prison.
My lord, I don't think anyone's doubting that basic proposition.
So you're saying it has to have something other than its ordinary meaning in the context of Section 117?
Well, I don't think I do say that. I think what I say is that it is implicit, it is clear that aftercare includes the planning.
Well, you say that. I just don't understand how you can receive aftercare while you're actually in the hospital or the prison. Any more than you can receive aftercare if you're buying a car before you've bought it, or...
I'm not sure. I noticed the time. I've got one. I think I've just got one last aspect to deal with on this very quickly. That kind of proves too much point. The ground 2. That's the only point I haven't really covered, and then I can deal with this.
Very well. Well, in that case, we will adjourn and resume at 2 o'clock.